Hi, this is Frank Stallone, and welcome to All Things P.I. with your host, Scott Ross.
Hi, good morning. It is Thursday. I don't remember the date anymore. We're joined in studio this morning at All Things P.I. with, I'm exploiting another friend of mine, Carl Douglas, attorney Carl Douglas. Carl is best known for, sorry to bring this up, buddy, one of OJ's lawyers, Johnny Cochran's partner.
No need to apologize, Scott. Thanks for having me here, man.
Well, I know, but you know, it's horrible because you kind of get defined by your cases. You know, I get equated with the Robert Blakes and the Michael Jacksons. You represented Michael Jackson as well.
Correct.
And you know, again, it's one of those things that unfortunately that's what people know you by. You know, we've worked together for many years.
After being a lawyer for 37 years, I have come to accept that will probably be in the second paragraph, if not the first paragraph of my obituary. So I've come to accept it, and that's good talking about it.
Well, I hope I don't have to read that. I hope you read mine long before I have to read yours. Although I do remember a phone call that I got that you called to tell me that you were in an Academy Award-winning documentary.
I was. The ESPN documentary, O.J. Simpson Made in America. It did win the Academy Award last year. I was so proud to have been a part of it. I wish I could have been invited to a party, if not the ceremony, man. But it was a great movie, and I really encourage any of your listeners to check it out. It's a 7-hour documentary, but importantly, as much as telling a story about O.J. Simpson, this magnificent documentary created by a guy named Edwin Edelman, it talks about the history of Los Angeles, the police department, and particularly the troubling relationship between the LAPD and the African American community. And I tell my friends, Scott, all the time that it's impossible really to understand with any sort of sanity how a jury could possibly have ruled that the prosecution had failed to find O.J. Simpson not guilty without understanding the distinct and unique history of the Los Angeles Police Department and the African American community here in LA.
And we've worked on other cases of that same nature. I don't think I'm really allowed to use the names because I know that some of them settled out. But the fact is that we've had several shooting incidences with LAPD, although one that comes to mind, the one was LA County Sheriff's, I believe. And the failure to prosecute that case, and especially when you have a situation where the investigating officers wrote a search warrant saying that bullets were whizzing by their head at 2:30 in the afternoon, and I specifically remember they said they saw a muzzle flash, that the bullets were whizzing by their heads, and I specifically remember that that was signed at 2:30 in the afternoon the following day when they recovered the weapon, and the weapon had never been discharged. That was just a blatant lie.
It is amazing. That particular case is one of the more striking cases over the course of my 37-year history when there appeared to have been blanket falsehoods by the police.
Right.
5 cops talking about the fact that bullets were whizzing by their heads, justifying why they shot a man who happened to lose a testicle as a result of the shooting, and then later coming to find out that the county sheriff's own criminalists concluded that the gun that he had dropped as he was running away from them had never been fired.
Right. In an unmarked van.
Correct.
That was in a gang area.
Correct. Driving slowly up to the street, and the people that were on a porch thought it was going to be a drive-by shooting, and
right.
They see a gun and they start running.
And I also want to point out that if I remember correctly, the initial allegations, the initial charges were 5 or 6 counts of attempted murder on a police officer.
Correct.
Reduced ultimately to was it a misdemeanor brandishing?
Brandishing, correct.
Yeah.
Correct. With the guy claiming he had a gun in his waistband and running when he saw the van pulling up.
Right.
Running away. And then realizing it's cops, he surrenders, and that's when he claimed while spread out on the pavement, one of the officers shot him in the testicles.
And as the investigator on that case, I also remember we had to go in search of They called in a civilian to run a metal detector. They were so hell-bent on finding a casing someplace to justify their actions, and they hit him. Yeah, but that was the sheriff's department. I'm not picking on LAPD, but that was the sheriff's. And then we had the other traffic stop that went bad. I remember that. That kid was unfortunately killed, and the police officer was rewarded with a brand new BMW. They moved him to Motors.
I remember. Gee, you're bringing back all these old memories.
Sorry.
There has been, not just in Los Angeles, Scott, in fairness to the district attorneys here, but nationwide, a tremendous reluctance to prosecute police officers for a possible misconduct. And that reluctance is borne by the results, tragically across the country, of difficulties in securing convictions involving law enforcement personnel, even in cases when there appears to be videotapes that show clear evidence of some seeming misconduct. I'm particularly thought of the incident in Minnesota a couple years ago, Philander Castile, a guy who was stopped with his girlfriend, and he had a gun and told the officers, "I have a gun." And he says, "I'm reaching for the gun," and the officer still shoots him. And his girlfriend is videotaping this on Facebook Live as it was going on. There was a criminal prosecution. He was found not guilty of manslaughter, yet the city awarded $6 million to his child. There are countless examples. The Freddie Gray case in Baltimore a couple of years ago, where there were a courageous state's attorney there had several opportunities or chances to try the officers separately. They were hung juries in every occasion, yet the family was paid a multi-million-dollar settlement from the city of Baltimore because of Mr. Gray's death. So the two don't really square. I understand there is a difference in the burdens of proof in terms of criminal cases and a finding of liability in a civil case, but clearly it shows how there's an overwhelming fear on the part of most of America that emboldens police officers because they give the officers on almost every occasion the benefit of every doubt.
And this is what we were talking about a little bit earlier this morning, is that this new law in California that will reverse, I'm sorry, I forgot it was
Graham versus
Connor, that will now change the justification of the police officers, at least in the state of California, to explain or justify, I guess, the use of excessive force.
Well, Graham versus Connor is a Supreme Court case which basically is the fundamental theory that officers are allowed to use that degree of force which is reasonably necessary to protect themselves or others. And it's the primary case setting forth the standard that there has to be an imminent threat of serious or deadly bodily injury before an officer is privileged to use deadly force. And I can't imagine that even as wild as the California legislature and sometimes the governorship can be, that there would be some sort of a modification of the fundamental concepts in that decision. But we'll see what happens.
And it's such a vague distinction because, again, it's somebody's perception of that physical threat. And I get from police officers all the time, you don't know what it's like, you've not been out there, all of that. Yeah, I get it. That's fine, and I appreciate it. But the fact is that nobody's made them take this job. And if it's something that you can't deal with, then leave. You know, I mean, if you are constantly in fear, this woman, this police officer in Dallas, who said that she went into the wrong apartment. The problem I have with that is if the apartments are all the same and they're all designed the same, when you walk into that, if you have the same apartment, you know where the light switch is. So before you pull out your gun and start shooting, you know, my thought process would be turn on the lights. You know where it is. All right. We have to take a quick break. We'll be back. Carl will be with us. You're welcome to text me, 818-744-9827, if you have any questions for him or me. You're listening to All Things P.I. with Scott Ross, and we'll be right back. Thank you.
NBC Talk Radio, KCAA 1050 AM. Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month, philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Bye-bye, sailor. No more sailing. Bye-bye, baby.
Okay, we are back in studio live with Carl Douglas. And again, just this, what I was saying about this shooting in Dallas. Like I said, the thing that bothers me is apartments. If the apartments are the same, then she knew where the light was. Why would you? And again, it's always that Monday morning quarterback.
There are going to be, I suspect, Scott, a lot of details that we have not yet heard that will come out. I've heard, for example, one version that when she came to the apartment on the wrong floor, it was suspicious because the door was somewhat ajar.
Right.
And she then walked into the appointment and saw this man in his own apartment, and that's what raised the concerns. I've heard other witnesses say that they heard a banging on the door from the outside first, before the shots were fired. So there's going to be a lot of questions, man. I don't know how someone in uniform, apparently just off of work, could have made so tragic a mistake and then have decided to take the ultimate recourse of using deadly force. One thing that was important that we kind of glossed over earlier in the discussion about the changes in the law is the consideration of whether or not the force used is reasonable has to be an objective consideration under the law. So you can't just say, I thought I was scared, and that's enough to justify my using force. You have to then be able to articulate facts, because they'll always say there's always the furtive gesture move. He made a motion toward his waistband, and I didn't know what was there, and so I made a decision to use force because I thought he was going to come out with a weapon. But there has to be articulable, objective facts that then are analyzed in consideration of whether or not the force used is reasonable.
But that analyzation is still coming from within the person doing the shooting. It still boils down to their perception of what they've decided to be a dangerous or life-threatening condition. I will give you a classic example. Again, we talked about that earlier, the homeless person that was shot by the police officer. Jackie Lacey refused to prosecute that one as well. Well, that was an ongoing issue that had been on videotape for quite a while. There was no issue of a weapon. The officer had a radio. He had a partner. The partner never drew his gun. The partner never felt threatened. And the fact remains that they could have called for backup for another 100 officers.
Scott, you don't have to convince me, man. Having been in this business for so long, I've had cases where a set of keys, a Bible, a box of cookies, all were mistaken for weapons. Men were shot in the back. And in 37 years of these kinds of cases, I've had one case only where the officer involved had been prosecuted. And that was a case of an old man stopped in a traffic stop. There was an argument. He pulls off. The cop then shoots at him for no reason, strikes him in the back, and that one officer was in fact prosecuted. Ironically, the city still refused to accept responsibility for the damages of the older man. We went to trial and returned a verdict of like $2.1 million. Wow. I think that was more than 10 years ago.
And then we had another case, I remember, a gentleman who was mentally ill out in somewhere in San Bernardino County, if I remember correctly.
You know, you could do probably an entire show about the challenges law enforcement places when dealing with the mentally ill.
Yeah.
I hear stories that perhaps more than 45 to 50% of the inmates in the county jail are suffering from some sort of mental illness currently. Officers are dealing with mental ill cases all of the time, and they are confronted, Scott, with the classic dilemma. Do I have to deal with this person who's mentally ill, or do I deal with the threat that's being presented first before me and then deal with the mental illness later? The classic case of a guy maybe who's crazy swinging a stick, man. And I have cases up and down the state of occasions when there's a crazy guy clearly has mental challenges, is suffering clearly from a mental breakdown. The family will call the police seeking help for the guy, and because he is not in his right mind and holding a stick, it's viewed as a deadly weapon. He's viewed as a deadly threat, and regrettably, ultimately, there is an officer-involved shooting. I have cases involving those kinds with sticks, with knives, with BB guns, all kinds of things. And that is a really difficult challenge that confronts law enforcement officers today. How do I deal with this circumstance? They say always, my first obligation is to go home to my family tonight. And so I'm going to deal with the threat first rather than try to play social worker. But that's a real challenge that confronts many of the cases that we're talking about now, including those in LA County.
I don't know if you're allowed to talk about it. I don't know where it's at because I haven't worked on it for quite a while. I did some initial work. The kid that was, I believe he was 19 years old, drinking up in San Jose State. And the police were called out. There was a confrontation. It had ended.
This is a real difficult week for that case. I represented the family of a straight-A student,
right,
who was a freshman at San Jose State University, and he came home intoxicated back to the dorm. Members of the dorm staff led him up to his room. He goes to his girlfriend's room, and they then call the campus police. He's on videotape with a body camera discussing the fact that he's drunk, but he's all right, and just let him sleep it off in his girlfriend's room. The officers take his name and his student ID, and they allow him to stay there in the room. And then, tragically, the next morning, he hangs himself.
Right.
And the school took no interest the next morning in inquiring, going to his room, to make sure he was all right. That case was lost on a technicality
of
where a claim for damages that I filed had been rejected, but I never received a copy of the rejection. And it was deemed to have been filed late. The lawsuit was filed late, and we just got a decision this week granting the dismissal of that lawsuit. That was a real tragic case. Thanks for reminding me about it today.
It was not intentional. But that's also sort of the other spectrum of the responsibility of the police. He was 19 years old. He was underage. He shouldn't have been drinking. And I think to leave him in the care of his girlfriend, who was also, if I remember, 18 or 19.
That could not have been the official police protocol of how you deal with an underage drinking student who you're supposed to be caring for.
And especially at a college facility that has medical facilities there, they should have taken him over to the hospital.
Correct, and they discussed those options as part of the videotape, which is even more tragic. Yeah,
I remember.
And he leaves a mother and father who loved him, and a younger sister who will always live with the memory of his death.
Sure, and a promising career. He was a really good student.
Very much so. His father was an engineer. Is an engineer.
So this case in Chicago, are you following this police officer who on videotape fired 16 shots? He emptied his 9mm.
Yeah, Jason Van Dyke is charged with the shooting death of Laquan McDonald. I went to college in Chicago, in Evanston, really, at Northwestern University, so I'm always still in touch with all things going on in Chicago. As you probably know, and your listeners I'm sure also know, there's a real epidemic of violence in the south and west sides of Chicago. That is really, really tragic. And I suspect it's going to be, that environment is going to be used to sort of paint a picture of the jungle that police officers in the Chicago PD find themselves in. Laquan McDonald was a young man who was shot 16 times, and the shooting was videotaped. And only after the videotape was released were charges brought against the officers, because the public uproar of the video of that shooting was so loud and so constant that the district attorney's office there had no real choice but to bring charges then.
And in fact, if I remember correctly, he was running away. It wasn't as if he was running toward the officer.
He was unarmed. There was, it looked like 10 or 15, 20 feet distance between the two of them. He was backing away. There were several cops there. And tragically, and it's often regrettably the way that I always find in many of my cases, the other officers that were there at the time did not report this abhorrent use of force. And they themselves are being punished and disciplined internally for failing to explain and describe what they saw.
And should be.
As well it should be. No, absolutely it should be. There is a tremendous problem in law enforcement with the code of silence. Police officers are hell-bent to avoid saying anything against another officer out of fear that they'll be labeled a snitch. And when they then need the officers to come and have their backs, they may be slow to respond. And this creates a culture in Los Angeles. It has been documented from as far back as the Christopher Commission, back in the 80s and the 90s, talking about how endemic and difficult a problem it is. And it continues to this very day.
Yeah, and becomes the subject of movies like Serpico, and becomes the topic of, even in the Rampart case, that was an issue that was brought out that the cops were covering for each other.
And Scott, I have a current case going on now where the police officer, a 12-year experienced sheriff deputy, denied ever hearing of the concept of a code of silence. Not, as opposed to saying, yeah, we don't practice that in our department. He, under oath, swore that he'd never even heard of the concept, to even have an opinion. He had never even heard of the Chuck Norris movie. And most cops will say, I heard the movie, but not in any practical sense. So it's amazing. The code of silence is alive and well. It is rare that I've ever had a case where I did not think police officers were saying things that were untrue to convict people who they thought were guilty. And that's a big problem with justice in America today.
Yeah, the best system in the world, I keep getting told. Okay, we have to take another break, so we will be back again. If you have any questions for Carl, you're welcome to text them to me, area 818-744-9827. You're listening to All Things P.I. this morning, Thursday, with Carl Douglas, and we'll be back. Thank you.
NBC Talk Radio, KCAA 1050 AM.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month? philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Okay, we're back. We're talking about, I don't want to say we're talking about police abuse cases, but we're talking about excessive force, and we're talking about cases with Carl Douglas that, again, if you have any questions, 818-744-9827, you can text the questions to me there. We were just talking off the record about the best system. So you say the best system is the United States, and I say it's England.
And
the Brits.
In America, we say it is better that 9 guilty people be found not guilty than 1 innocent person be convicted. I think that is the best system. There should be a presumption in favor of innocence. It should be hard to convict someone of a crime. And the proof in the pudding, Scott, is the number of people on death row that you find and you discover that have been proven years later to have been found not guilty because of the different innocent projects around the country.
Yeah, and I support those.
I'm on the board of the Innocence Project at Loyola here in Los Angeles, and I'm a strong supporter. Lori Levinson and the team there are doing a fabulous job, and it speaks to the problems in our system that people can be on death row who are actually factually, in many cases, not guilty, but the wisdom of making it so that it is much harder to convict someone of a crime. And I think that's the best system on earth as a proud American.
You know, there's also sort of an unspoken prejudice that nobody's ever discussed or brought up. I had a death penalty case recently, a kid named Darnell Washington. I don't know if you're familiar with that at all. Essentially, his wife helped him escape from prison in San Bernardino. He got into a shootout with a police officer, a sheriff's deputy in El Monte, and then drove up to Northern California, did a home invasion, needed a new car. So they did a home invasion and killed a school teacher up in a little town called Hercules up in Contra Costa County. And then he and his wife fled north. They got stopped about 100 miles south of the Canadian border in Washington. You remember that case at all?
No, I don't. It's interesting.
The media was calling them the Black Bonnie and Clyde, which is beyond idiotic. But what was interesting about that case is the wife was an equal participant, and the state of California has no avenue for a death penalty female. They don't have the proper housing that's required for women. Women do not get charged with the death penalty. Darnell was charged with the death penalty. He was He was convicted, placed on placed on death row, and his wife ultimately was given a deal and never charged in the death penalty.
How about the women that were convicted in the Tate LaBianca murders, the Manson family women?
They were given the death penalty sentence, but that was ultimately reversed. And again, that was an issue back then, as there was no place to house them because the death penalty case comes with so many different. The criteria is different as far as housing and giving them availability to their attorneys in the state-appointed or state-funded appeal, I should say. That was an issue that I talked to the attorney about, filing a demur for discrimination,
Wow.
saying that it's not reasonable to charge him simply because he's the male, and you can do that as opposed to the female.
Well, this is what's the fabulous thing about all things PI, man. I've come on here and I've learned 2 bits of knowledge just in the first 20 minutes. You're just bringing the knowledge to me, man. Thanks so much.
Well, that's where it ends because I only have 2 pieces of information that anybody would know. And there's a new law that they're getting ready to pass or not pass. Again, it was one of the other laws that was sort of put together with the bond issue. You and I talked about that, and we can continue to talk about that. The state of California is getting ready to eliminate the felony murder rule. And in fact, this law actually provides for resentencing of people who are currently in custody for that. That if you're not the shooter, you don't need to go to prison for the rest of your life. Now, law enforcement is obviously up in arms because that's part of their bargaining tool to get defendant 1 to roll on defendant 2.
And for those of your listeners who are not aware, the felony murder rule is basically a law that says that if during the commission of a serious crime, like a felony, someone dies and the death is foreseeable because you're doing something that's serious and violence is possible, the participants in the felony can each be charged and convicted of the murder, no matter who's murdered. So if, in fact, in a robbery, the co-defendant is murdered by the police, you can use it in that way.
Right.
Or if an innocent person in the getaway driving away is injured, the person in the backseat of the car can certainly be charged. And it is a hammer that is used by district attorneys up and down the state to give leverage so as they can secure cooperation deals from less involved defendants against the bad person, or to secure convictions rather than risking a lengthy prison sentence upon conviction. You get plea deals that way all the time.
And that law is about to go by the wayside. And like I said, it actually allows for resentencing. So if somebody was the driver, and I had a case years ago out of Hollywood, LAPD case out of Hollywood, where these 6 kids went to have a confrontation with a couple other kids, all in one car. And in fact, one of the kids in car A pulled out a gun, shot and killed 2 other people from car B. The 6 kids jumped in the car, and the driver, as he sped away, took the gun and threw it out the window. People had called 911, so the police were en route. They saw the Mercedes as it was driving down whatever street it was, and the officer saw something flying out the window. They stopped the car, pulled him over, and ultimately found the gun, and he tested positive for GSR because the gun had been fired, and he handled it. Anyway, short version is that the witnesses, he was clearly not the shooter. The driver was about 6'3", and the shooter was identified as being someone who was about 5'6". So he's probably been almost 20 years that he's been down in state prison. And again, this law now, restructures sentencing. And his position was he didn't know that the gunfight was going to break out. But under the felony murder rule, that just doesn't matter.
But, and I'm not familiar with this law as well, but I would think, Scott, that it's going to be a monumental challenge if you're going to retroactively go back, 3 years or 5 years or 10 years, and then trying to re-secure the evidence or the witnesses whose memories may have lapsed or people may have no longer be alive now. I could appreciate it being applied prospectively in the future, but if the thought is that you're now going to go back an X number of years and have a reanalysis of those cases where someone was convicted under the felony murder standard, that's going to bring the system to a halt, don't you think?
And since you're not an investigator, and I am, I will also tell you that because it's a murder case, evidence is maintained for 30 years in a murder case. So since there was a murder, the files, the evidence, all of the information from the trial, and even if, well, nobody's pled out, but all of that is still structured and maintained for 30 years, at least by LAPD and LA Sheriffs.
And what's the standard? If the analysis uncovers that someone was sentenced, though not the shooter, he can be resentenced?
Correct. So in theory, in the case that I just discussed with you, so he's taken the position, the driver's taken the position that he didn't know that the passenger had a gun. They were going there to have this, for lack of a better term, confrontation with these other group of kids. I can't say anybody was a gang member, but this other group of kids. And the fighting, the gun was pulled out, and this one shooter starts shooting at people, killed 2, hit 3 of the other kids, and then they drove away. So if he takes the position that I didn't know he had a gun under the felony murder rule, it's sort of a moot issue because they went there to be confrontational. But that law now allows for restructuring because it says that I guess the state would then actually have the burden to prove that he knew that there was a gun or that the shooting was going to take place, and that's never going to happen. And you're right, it's reinventing the wheel.
Okay, I'll go on record saying I doubt that law will be signed in a way that allows for past convictions to be reanalyzed if it's more than, let's say, 2 years past.
Yeah.
It might be applied prospectively, but the manpower that it would take on both sides of the aisle, not only with district attorney offices throughout the country reevaluating, but also hiring defense lawyers to, again, have rehearings on those cases would cause the court systems in major metropolitan areas to grind to a halt, I suspect. And there is going to be uproar, not only with police department agencies, but district attorney offices and staffs, and everyone is going to be burdened, I think, if such a law is placed into effect. So much so that I think it will not be signed. How about that?
Okay, and that's possible. And I really never thought that no bail law would be signed. I think that's insane.
And I am still learning more about the implications of the new Bail Reform Act. I have colleagues who are bail agents and bail bondsmen who are crying out, thinking that they're going to be out of business in 2 years. But the new law, which, as I understand it, is going to allow for a pretrial agency to categorize suspects or defendants upon their arrest into 3 different categories. Right. Most will go into a low offender category, because most arrestees are arrested for drug or minor offenses. Mm-hmm. They'll be able to be released immediately. The higher group, those charged with murder or serious offenses, will be held immediately. And then I'm told the middle group is going to be analyzed for some process that each county is going to put into place. I know in my experience, man, it is a tragedy that bail is more often a financial thing as opposed to something that is done to actually secure the appearance of the person charged with a crime. And often being in jail is the primary motivation for a defendant to plead guilty to something that he may or may not have done than anything else. So for those reasons alone, I am in favor of a reform of the process where people, 40% of those that are in custody are there because they cannot make the financial bail. And under this process, they would be released. That is the overwhelming majority of drunk driving cases and those kinds of cases. And I think it's a good thing, though not a perfect law.
Yeah, it needs massive reform. All right. Well, again, we're going to take our last break. 818-744-9827. If you have any questions, send over a text, and we'll be back with Carl Douglas in a few minutes. Thank you.
NBC Talk Radio, KCAA 1050 AM.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month, philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Okay, we're back, and Carl's upset that I don't follow sports, and I didn't know LeBron James was coming to Los Angeles.
Correct. I'm serious about that.
I'm sorry. We can sit here and talk sports if you'd rather.
No, it's okay.
Let's talk about the athletes that keep getting arrested. Let's talk about those.
Right.
Ray Caruth recently got out of custody. I don't know if you remember that case.
Sure.
Yeah.
Tennessee.
Yeah. Dave Rudolph was a guest on the show, his attorney. But anyway, we won't get into that. So what we were talking about, too, was the bail reform. And my concern with the bail reform is that, you talk about the three levels. The fact is that there's other qualifications. For example, if you've had 2 prior DUIs within 5 years, even though there's no injury, there's no great bodily injury or accident, just being pulled over, you're not entitled to bail on that third one.
Well, to be clear, every new law, I believe, has things that may be wrong with it. There is no perfect law that is first instituted. And what we have to assume or hope is that as time goes on, there will be adjustments made, and these anecdotal exceptions that you have in mind, and I'm sure there are others, are going to be publicized, as you are, through shows like such as these, and those anecdotal unfairnesses will be taken out. But I think personally that, and there was a story recently on 60 Minutes about people who are innocent factually and pressured to plead guilty because they want to get home.
Sure.
And that, I think, in a country of this greatness is an abomination. And they are in custody because they cannot make bail, not because they are a threat or a danger or a cause for concern to not reappear in court to face the charges against them, but simply because they can't afford it, and they'll lose jobs, and their families are impacted by this, and it is not for the greater good. So a transformational change in the bail system where the overwhelming majority of arrestees will be given the presumption that they are not a threat and that they can be released and that they'll return to answer the charges, I think is a good thing, even though it is fraught with problems, and even though I concede it is not the perfect law and there will be things that need to be reformed and changed.
Yeah. In fact, one of those cases that comes to mind, and I'm not going to get into any names, but I had a case. It was a vehicular manslaughter where we could prove that this gentleman, it was a solo vehicle rollover. We could prove conclusively that he wasn't driving, but it was his car. And The DA didn't even really dispute it, but they offered him 3 years, felony, 3 years, and no jail time. He had 3 kids. He had 3 little girls, wanted to go home to his family, didn't want to go to prison, and took the deal for something that he just flat out didn't do. And again, it wasn't about the truth of the matter. It was really about just the prosecution had too much time and energy involved in this case, and they weren't going to walk away.
And Scott, it is cases such as those, and you have a lot of clients, man, who may not be guilty. I mean, that's a unique circumstance that you have. But there are countless cases, particularly, in the public defender arena, where the defendants are unable to afford a Scott Ross, for example. They can't afford a Tom Mesereau, who's a great defense lawyer here in Los Angeles, for example. And because of their economic circumstance, they make decisions that impact their lives and their families. In California, man, with a felony conviction, you can't vote anymore. So there are, dramatic impacts based on decisions that are made for an economic component and not because of a justice component. And I think that is bad, and an attempt to change fundamentally that system certainly has collateral implications on the bail industry. And I know bail bondsmen are going to be rallying and donating money to put a ballot measure on the ballot so that we can suspend this law. But I do think having some fundamental reforms is important and positive, and I'm glad that the state of California, once again, is leading the way.
And I agree with that, but I think the biggest fly in the ointment with this law is that it gives the victim essentially, not to be confused with sentencing, it gives the victim sort of an impact statement. They have a say in whether or not somebody, and if it's done within a 48-hour period or a 24-hour period or even a 6-hour period, you still have that emotional aspect of the victim still being angry, whatever the case may be. And I think it's unreasonable, because if the defendant wants to defend themselves, they're going to have to sort of walk away from their Fifth Amendment privilege to say that's not what happened.
But, regrettably, man, the bill was the result of a compromise. And one of the concessions that the sponsors of the bill had to give was to the victim rights advocate piece in California. And you had to give something to that constituency, or this bill would never have gained majority support in the Assembly and the Senate to have gone and be passed on to Judge Brown, to Governor Brown. So that is a disturbing component, I agree. But the process of creating a bill is not for the faint of heart. The old saying, making hot dogs legislation, something you don't want to see. You got to compromise to have it go through. And there are several less preferable components, I agree, that are in this bill, but they are the result of weeks and weeks of negotiation. And there would not have been a bill that came out of committee and out of the Assembly unless all the constituencies and all the stakeholders had their concerns addressed. And I suspect that was the Megan's Law piece, the Kelsey's Law piece. Those victims advocates were insisting on something to say for them to go on the bill.
And with Megan's Law, you're right, because with Megan's Law, not all registered sex offenders fall within that jurisdiction of being able to determine or run a name through a Megan's Law computer to determine whether or not somebody is a threat. But part of the other problem, too, is the LAPD for years has been allowed to stack charges. So when they pull somebody over, so they stop them for driving under the influence, then they find a gun, then they find whatever, then all of a sudden your bail ends up being $250,000.
It is the tremendous discretion that police officers have at the scene of the incident. And they use it punitively. They use it tactically. It's done to, they will say for their own investigative purposes. They want to keep people in custody as long as possible so that they can continue to conduct their investigations, right. Those kinds of things. But certainly it is is the way the process is, and police officers there at the station house have tremendous influence on how bail is initially set, because judges give great deference to the bail settings that are done mechanically when the case first comes to their courts.
And, the other issue, and I don't know how Chief Moore is going to look at this, but I know that with Charlie Beck and your old friend, Bernie Parks, one of the issues is because there's matching funds that they get from the government with the crime stats. So if somebody's arrested, for example, in assault with a deadly weapon, 245A1, that's a wobbler. They always get booked on the felony. They never get booked on the misdemeanor, because those stats obviously ultimately are turned over to the federal government, and they say, we need an extra $3 million, and here's why.
All of that, I am sure, is interrelated. Conviction rates, I'm sure, has some impact on all of that. And it is great latitude is given to the prosecutorial arm of our government, because most Americans give them the authority to keep us safe. And if by keeping us safe it means locking the bad guys up, they're going to allow that to occur. And as liberal as California has a reputation of being, remember, we're still a state where there's the death penalty. There's very conservative portions of the state, and basically outside of the Bay Area and LA County, the majority of the state is very conservative. And so this position is part of a larger trend that is here, not just in California, but nationwide as well.
Yeah. And California's budget, I don't know if you're aware of this, I think it's close to 33 or 35% of the entire budget for the state of California is the Department of Corrections.
I am sure. And we still send inmates from California to neighboring states. I just had a case in Arizona. They sent them to Nevada because there's room there, and, paying great sums of money to ship out, incarcerate. It's a big industry.
Yeah. Oklahoma. I had a client who was sent to Oklahoma. And the state of California just doesn't have. In fact, the state of California was in such, I don't know what you call it, malpractice, whatever. They weren't taking care of the inmates properly. I think it was 1996, the federal government had to step in and take over the medical care at the prison. It's
difficult because, under California law, you cannot sue the state because of medical negligence or any kind of negligence to a prisoner or by a prisoner. So they have no recourse. If there's some sort of medical problem, there's nothing you can do legally to vindicate the violation of your rights, which is life here in America.
Yeah, and not that he's entitled to it, but a friend of mine who actually works at a hospital in Bakersfield told me that Charlie Manson had been brought there several days before he died and virtually unconscious. I mean, they sort of just let him sit in the cell till there was no chance. And again, I'm not saying that Charlie Manson was entitled to what that he was entitled to any medical treatment, but the fact is that they need to be treated better, the inmates, and you clearly don't think I should be saying that.
This is your show.
Okay. What else are you working on? Are you keeping busy? You've got Jamon Hicks as your new partner.
He's been my partner for 4 years.
Time flies.
Not very new.
I remember when he was still in law school.
Absolutely, yeah. He's working with me then. We're doing well at Douglas Hicks Law in Los Angeles, trying to bring justice in this community. And with Godspeed, we'll continue doing so for years to come.
And if somebody wants to reach you, how would they do that?
Carl Douglas Hicks Law is our website. My number is 323-655-6505. I'm on Facebook. I'm on Twitter. CEDESQ.
CEDESQ. Carl E. Douglas.
Right.
From Chicago. All right. Again, thank you, everybody, for listening. You've been listening to All Things P.I. with my exploited friend, Carl Douglas. If you have any questions for Carl, you have his phone number. You have our phone number. We'll be back next week. And again, thank you for listening.
Have me back. Certainly, I can talk about
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
This is a special report from NBC News Radio. Hurricane Florence. The outer bands of Hurricane Florence are beginning to rock the North Carolina coast. Right now, Florence is a Category 2 storm with top sustained winds at 105 miles per hour. NBC meteorologist Bill Cairns.
I really don't care if it went from a 4 to a 2. All that means is that the extreme winds around the center will do a little less damage. Storm surge, still the same. Could be record high. Rainfall could be record high. River flooding could be record high throughout the area. The slow-moving storm is expected to be a major flooding event, and authorities are warning about deadly storm surges and possible mudslides in parts of the Carolinas and mid-Atlantic states. When Florence will make landfall is not clear, but it's expected to happen in the next 36 to 48 hours, probably in North Carolina. The Pentagon sending troops to help out as Hurricane Florence closes in on the Carolina coast. The Army and Air National Guard has activated nearly 3,000 soldiers to aid in search and rescue, distribute food and water, and clear storm debris. Tom Roberts, NBC News Radio.
It's time for traffic on KCAA. I'm Erin Brinker. In Chino, we have a really gross SIG alert on the 60 westbound after Mountain Avenue. Lost sacks of cow guts are in the 3 right lanes, and traffic is completely stopped from the 15. In Beaumont, on Highway 79 northbound between Gilman Springs Road and Lamb Canyon Road, a multi-vehicle wreck has the right lane closed. Stop-and-go traffic is backed up from the Ramona Expressway. A possible alternate route is to take Gilman Springs Road to the 60. It's a long way around, but it's a better option. In Riverside on the 91 westbound at Van Buren, Caltrans has the right lane and Tyler off-ramp closed for this work zone. Stop-and-go traffic is backed up from Madison. In Rancho Cucamonga, there's slow traffic on the 210 westbound between Milliken and Foothill. And in Colton, an accident there has been cleared on the 215 southbound after Mount Vernon Avenue / Washington Street. The 215 north is heavy from Cactus to University. The 60 west is busy from Day Street to the 215. This has been your traffic report on KCAA. We are the stations that leave no listener behind. I'm Erin Brinker. This report is brought to you by Compassion International. Sponsoring a child with compassion is the most effective way to end extreme child poverty. Sponsor a child now at compassion.com/radio.
Every day is a great day at KCAA Radio. September 13th is National Kids Take Over the Kitchen Day. Now, kids and teens across the country are called to take over their kitchens on this day using their favorite recipes and make a meal for their family. Today is also Uncle Sam Day. Now, the man behind the iconic image and fascinating nickname for the U.S. government is recognized on Uncle Sam Day. Born on September 13th, 1766, Sam Wilson, a meat packer from New York, supplied barrels of meat to soldiers during the War of 1812. To identify the meat for shipment, Wilson stamped the abbreviation U.S. on the barrels. It wasn't long before